Rihanna. I posted something in the group. about Rihanna having some trademarks. She's being sued. Somebody filed a lawsuit against her on Wednesday. A company called Freedom United. And it's FU. And then underneath is Freedom United is their trademark. But first of all, before we get into that, who knew that Rihanna's last name was Fenty? I didn't know that. I did not know that at all. So I like doing this podcast because I feel like it's mutually beneficial to you and me. So for you guys, you get to learn about legal concepts and get it broken down in a way that you can understand it. And for me, I get to stay in the know with pop culture tidbits because I had no idea that was her last name until I started going into the USPTO database. And I was like, oh, Robin, Rihanna, Fenty. Who knew? Not me. But anywho, she's being sued because she has a clothing line. Well, something's called Fenty University. And hers has F period, U period, and underneath it says Fenty University. And she's being sued by Freedom United for basically unfair competition, trademark infringement, because of her use of that. Here's the thing. All the images that I've seen with her, with this FU mark, it's used as a design. It's used as a design on clothing. It's not used as a trademark. And so if she were to put that FU with the Fenty University, and give it, and she was applying for a trademark, and she said, here's my proof that I'm using this as a trademark, her application would be denied. Because USPTO would say that FU with the Fenty University at the bottom of it is not a trademark, it's a design. And same thing with Freedom United. They have FU with Freedom United and on the front of some of their clothing. That's a design. It's not necessarily a trademark. On Rihanna's actually clothing, the one that has the FU on there, it has the brand identified as Fenty by Rihanna. She's not even using the FU or Fenty University as a trademark. She's literally using it as a design. She has over 100 trademark applications that have been filed. And not one of them were filed for FU, Fenty University, or Fenty. They weren't filed for FU. They weren't filed for Fenty University. They weren't filed for FU with Fenty University combined. She is not using this as a trademark. She's using it simply as a design. And there is a difference when it comes to trademarks. There is a difference between using something as a design and using something as a trademark. And when I'm thinking about this, so then the first thing I hear you guys saying was, does that mean that I can put Waffle House on a shirt? Does that mean that I can put Nike on a shirt and not be sued? No, because those are actually marks that have, what's the word I want to say? Those are prominent marks. And when we know down here in the South, I don't know if they have Waffle Houses up north, but those are prominent trademarks. FU is not distinguished enough to be identified immediately as a trademark, especially when you have the Fenty University under there. I didn't know anything about an FU clothing. Apparently, I think they're out of the UK. I'm not 100% sure. But when I see FU, especially, I don't think of Freedom United. I don't. I don't think of Fenty University. I don't think of anything. I think of the curse words personally. When I see FU, that's the first thing that pops in my mind. Another thing that I thought was really interesting about this about this FU trademark case is that Freedom United, they actually have their trademark certificate on their website. I've never ever seen that, and I just think that it's them trying to bolster their case that, hey, this is a registered trademark and you guys can't use it. And I think what they might be trying to do is prevent people from using FU on clothing, which you can't do. People can put FU on clothing because it's a design, not a trademark. And anyway, what they're asking for, so let's talk about a little bit about this unfair competition. This unfair competition is essentially that someone being dishonest or having a dishonest or fraudulent practice of using a person's good or passing their good off as another person, either through counterfeit or imitation. Imitation. Imitation is the word that I'm trying to say. Okay, people? That's it. And so at its very heart, unfair competition is trademark infringement, right? Because trademark infringement is the fraudulent passing of one's good as another. So that's what they're alleging or accusing Rihanna and Puma, because this FU University, that was in conjunction with a fashion deal that she had with Puma, which is my understanding from fashionlaw.com that they're no longer in partnership together. But at the time they were, so they had this thing where it was Fenty by Rihanna and she had different clothing, and one was like Fenty University, which is the subject of this lawsuit. So Freedom is asking for an injunction. Now, about 3 weeks ago, we talked about injunctions, and we know that in order to get an injunction, first of all, what is an injunction? An injunction is someone asking the court to prevent a party from doing something before there's even been a trial. Like, there's been no trial that says, yes, you're right, or no, I'm wrong, but they're asking the court to step in and stop them from doing something. And in this case, they're asking the court to stop Rihanna from selling these FU products without there even being a trial, without there being a determination of right or wrong. So in order to get an injunction, they have to be able to show the extent of irreparable harm, meaning that if you don't grant us this injunction, we are going to have, this is going to be the damage. This is how it's going to affect us, and it's going to be really bad, and we're not going to be able to stay on top of it. In their case, they might say that we're going to lose customers and clients to these people because they think that they're buying Freedom United clothing when they're really buying Fenty by Rihanna clothing. The second thing they have to do is show, or the second determination that the court has to make is like each party's likelihood of success at trial. So we're not just going to grant you this right to stop these other people, in this case, from making money just because you asked us to while trial is pending. We need to know, one, how, if we don't, what's going to happen to you, and two, like, do you even have a case? Like, is there a likelihood that you might win, or is there a likelihood that you might lose? We need to look at that kind of stuff before this injunction is granted. Now, like I said, everything was just filed on Wednesday, so the court hadn't had time to rule on anything. Rihanna's people haven't had time to respond to this particular lawsuit. When I was researching, I noticed that this is not the first time Freedom has brought this up. They sent them a cease and desist letter back in April, to which Rihanna's people said, hey, we are not infringing on your trademark. And let's talk about, so they might not be infringing on their trademark, so maybe what another line of offense, I would say, would be maybe copyright infringement with the FU, right? But again, we know that copyrights don't protect short phrases. However, if Freedom United had a unique font that was created for them, then they could have grounds for infringement if Rihanna had actually copied the font as well. But in this case, she didn't, and that's what her attorney said, that, hey, this is not, first of all, FU is not distinguishable enough as a trademark. Second of all, we're not even using the same type of font, and it's not exactly the same. You know, theirs is just FU with Freedom United underneath. Rihanna's is F period U period with Fenty University at the underneath. So they're saying that it's distinguished enough that the FU Freedom United is not distinguishable enough as a trademark, meaning that when people see our shirt, they're not going to think of you. Like, nobody's thinking of you when they see Fenty University on this hoodie or on these slides or whatever. So that's what I have. So I guess if I can say our top 3 takeaways from the Rihanna situation, it would be one, matter of fact, before we get to our top 3, let's talk about trademarks in clothing. And I think I've touched on it, but I want to go back again and make sure that you guys understand. Because I have a lot of clients and potential clients who are looking to start clothing brands, and they have these great designs, and they're like, oh, I want to trademark my logo. And it's a logo that they're just simply putting on the front of their shirt, and everything else is not branded. So that's not a trademark. What you have to do is take that logo, take that trade name, and actually make it a brand identifier, meaning that it needs to be on a tag, it needs to be on the product packaging somewhere. Just like when you go to the store and you buy a t-shirt and you look at the tag and see who it's made by, or someone says, "Ooh, girl, I like that dress. Where'd you get it from?" Or who made it? You kind of look at the tag and say, "Oh, it's Gap," oh, it's Hanes, or blah, 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 blah. That's what people have to do with clothing. When you just take an image and you put it on the front of a shirt, that does not tell people the source of that shirt. So for that reason, it's not a trademark. So that would be our tip number one. Our takeaway number one is that when it comes to clothing, you have to make sure that you are actually using your mark as a trademark and not a design. If you just have an image or something on the front of the clothing or article of clothing, it's not a trademark, it's a design, and it won't be approved for trademark registration if that's the only thing you have. The second thing we'll take away from this is that trademark infringement is at the heart of unfair competition, meaning that they can sue you not only federally, but they can also sue you on the state level, which is what Freedom is doing. Freedom is actually suing Rihanna in New York for unfair competition under their state laws. And the third thing, what would be the third takeaway from this? The third takeaway from this is that you have to be careful. If you are in fact using someone else's mark, you have to be careful, because if they ask for an injunction, not only can they prevent you from selling the products, but they can also ask for money. They can say, hey, and which is what they're doing in this case, they're saying, hey, we want damages from the profit she made from selling this FU products. So you have to be careful out there. Make sure before you start using a mark or a brand that you do a trademark clearance search and make sure that you're not infringing on someone's brand. Protect your own brand, and we've talked about numerous ways to do that. And it's at the very beginning. This lawsuit is at the very beginning, so I'll be very interested to know if it'll make it. I wouldn't be surprised if Rihanna's people filed a motion for summary judgment. And what a motion for summary judgment is before we go to trial, based on the law, the facts. So basically what we're saying is there's no dispute on the facts. Like, everybody agrees on the facts of this case. And so if you apply the law to these facts, this must happen. So when you're filing for a motion for summary judgment, you're asking the court to make a determination based on agreed upon facts, just on the law. And the law says that because X, Y, and Z are the facts, then we must prevail. That's the motion for summary judgment. And I wouldn't be surprised if Rihanna's people filed a motion for summary judgment to have the case dismissed before trial. So that's what I have for you today. Thank you so much for joining me, and have a great weekend. Have an amazing weekend. I will talk to you all later.